Welcome to the Probate Nation. Probate is a process to transfer the title or ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. But in order to start the probate journey, someone needs to be in charge of driving the probate train. The title conferred on that person is executor or administrator, and they may be named in a will or volunteer to serve when there is no will. Regardless, that person is not empowered to drive the probate train until they are appointed to do so, and there are steps that they need to be taken to get legally appointed. Today we learn from the experts on how to initiate probate in Loudoun County Circuit Court. And we are honored to have with us today the clerk of the Circuit Court in Loudoun County, an elected position he has held for the past 16 years. Prior to becoming clerk of court, he served as case manager and investigator for the Office of Commonwealth Attorney and the land records manager for the clerk of the Circuit Court in Fairfax County, and a paralegal with Aaron Fox Law Firm. He has served as the president for the Virginia Association of Constitutional Officers and as the president of the Virginia Court Clerks Association. Please welcome Gary Clemens, clerk of the Circuit Court in Loudoun County. Gary, thanks for taking the time to talk with us today.
Thank you, Mr. Wright. It's an honor to be here. Thank you for the opportunity.
It's our pleasure to have you. I know you've served as the clerk of court for many years now, you see how states handle probates across the country. How does Virginia's probate process compare with other states?
I like Virginia's probate process because you have an elected constitutional officer and your clerk of circuit court who is the adjudicator of a probate case. In many states you'll have a probate court. We have judges who preside over the cases, and those cases may take a longer period of time to adjudicate because you have to make court appearances, have hearings, and other meetings. Whereas in Virginia, you can essentially call your local clerk of the circuit court when you've had the unfortunate experience of you losing a loved one and schedule an appointment to meet with the clerk or the clerk staff. So I think having that available to our citizens is very valuable. That's
very, very true, very true. Now, Loudoun County, one of the fastest growing counties in the country, how has that growth impacted your office?
It has impacted the probate operation significantly. When I first became clerk, our population was around 120,000. Today we have a population of 375,000 in Loudoun County, and Loudoun County has been one of the fastest growing counties. That's a direct impact on our probate operations because as our population has grown, obviously you're going to have more people who die in your county and have to go through the probate process. So it's had a direct impact. In fact, we never had a probate department when I first became clerk in 2000. By 2002, I realized that with our growth, we need to have a specialized probate department. And I asked our Board of Supervisors to provide funding, so we created our first probate manager, a gentleman you'll meet here very shortly. And over that time period, in the past 16 years, we've added 2 more employees, so I have a team of 3 people, whereas when I first became clerk, there really wasn't a probate department. So we've come a long way, and I think we've addressed the growth very well in that regard.
I think very much so. Now, some people die with wills and some people die without wills. Can you explain the difference just briefly for our viewers?
Well, if one dies without a will, that's called an intestate estate, and I would encourage people to avoid not having a will. It can become rather complicated and cumbersome because you have to bring witnesses in, essentially have a hearing to determine what the desires were of the decedent being the person who's deceased. Whereas if you have a will, there's no guessing game. And it's less cumbersome and less complicated because with a will, the decedent's made it very clear legally what they want to have happen with their affairs, their assets, their property, and most importantly, their children. If there's minor children involved, you definitely want to have a will because you don't want necessarily the court or other entities deciding what's going to happen with your children. I think it's important that you have a will to set forth who's going to be the legal guardians of your children. So for many, many reasons, I do advocate for people having a will. It makes it easier for my staff to do their jobs to serve the citizens when they have a loved one who has been lost and they have to come and have the probate process conducted.
I think that's good advice. How many estates, have been opened over the last, year or so in Loudoun County?
In 2015, we had 561 probate cases opened. That's about the norm year after year. However, several years ago in 2012, we exceeded 800. So it can fluctuate, but our average is about 560, 570 a year.
Okay.
And some of these get very complicated. That's why it's important we have a team of professionals who know the probate process, who can provide that kind of valuable assistance you need to provide when someone's going through the loss of a loved one.
That's good. Now, with this growth, is your population out there aging, and is that having any impact on your office as well?
Well, since our population overall is growing, there is a larger segment of the aging population, but the median age of Loudoun County residents is in the 30 range because Loudoun County has a lot of children. That's why we have a lot of schools in Loudoun County. But overall, the population as a whole is growing, and therefore it has a direct impact on probate because we do have more residents that unfortunately pass away. And again, our citizens need to know they have a valuable team of probate professionals there ready to assist them.
That's great. Is there anything further you'd like to share with us about the probate office, and given your experience over the last many years?
Well, one may conclude that I'm biased because I'm clerk of the Loudoun Circuit Court, but I'm proud of my probate team. I think we have one of the best probate departments in the entire Commonwealth of Virginia. We have a manager who has many years of experience that exceeds almost 4 decades. That's valuable to have that kind of experience. My other team members are very valuable as well. Overall, it's a great probate team that knows providing great service to our citizens. The other thing I just want to share with you, Mr. Ruddy, for your viewers, is get a will. Sit down and talk to an attorney. People may feel like they don't want to pay an attorney for that service, but it's a good investment, because then there's no guessing game later on when someone passes away as to what their desire wishes are with their estate and their assets, and again, most importantly, one's children. I think anyone should know they have to have direct control over the outcome of their estate and their family, and you can do that by having a will. So sit down and talk to an attorney and have a will drafted. Don't ever put your family in a position of having an intestate situation.
Well, that's good advice. I want to thank you for your commitment, and service to the citizens of Loudoun County and to the Loudoun County Circuit Court, and for taking the time to visit with us today, talk about all of your experiences and advice about what people should do in the context of preparing for dealing with their estate. And again, thank you again for your great service to our community.
Well, thank you for this opportunity very much.
You're very welcome. We're going to take a short break, and then we are going to return and talk to the folks from the Loudoun County Probate Office and hear how to do each step of the way and you get qualified. Welcome back. We now turn our attention to some of the nuts and bolts involved in starting the probate of an estate in Loudoun County, beginning with getting appointed to drive the probate train. With me today are the 3 members of the Loudoun County Circuit Court Probate Division. Bill Lloyd started working in the clerk's office on February 1974. Since that time, he has recorded deeds, docketed judgments, filed court papers, assisted in court cases, managed court evidence, issued marriage license, and probated wills. And in 1991, he became Assistant Chief Deputy Clerk. In 2002, the first official probate division in the clerk's office was established, and Bill was appointed as probate manager. In August 2011, Bill was the recipient of the Distinguished Career Service Award from the Virginia Supreme Court in recognition of his decades of exceptional contributions to the court systems in Virginia. Also joining us is Lori Gordon, who has been with the Loudoun County Circuit Court Clerk's Office for 13 years and with the Probate Division since 2009. And finally, Joy Hayes has been with the Loudoun County Circuit Court Clerk's Office for 11 years and joined the Probate Division in 2015. Please welcome the members of the Loudoun County Probate Division. Folks, welcome. Thanks for coming by to talk with us today.
Thank you.
So, Bill, what is probate and why is it really necessary?
The Code of Virginia gives the clerk of the circuit court the probate powers. Therefore, probate is the legal process where the clerk grants the legal authority to someone to administer the estate of a deceased person. No one has any authority to administer the estate until they appear before the clerk and complete the probate process and are granted that power by the clerk.
Okay. Now, Lori, we get qualified to probate, but what are probate assets?
Probate assets are typically any asset that is held solely in the decedent's name. To name a few, it could be bank accounts, stocks, bonds, even real estate.
Okay. So how those assets are titled becomes very important.
Absolutely.
So, Julie, give us some examples of assets that are not probate assets.
Examples of assets that are not probate assets would be any accounts that are held jointly with right of survivorship, any accounts that have a designated beneficiary listed, or any account that may have a transfer on death or payable on death listed on the account.
Okay. Now, Bill, what's the difference between being a beneficiary and being an heir at law?
Beneficiary is the person who inherits the assets of an estate. An heir is the person who meets the definition by the Code of Virginia to be the closest living next of kin. And those are not the same for every estate.
Very, very true. So just because you're an heir at law does not mean you're
you're a beneficiary.
You're a beneficiary of the estate. Now, Lori, can anyone act on behalf of the estate?
No, not anyone. Someone would need to contact our office, and they would have to go through the probate process and be formally appointed as a personal representative. Once they go through that process, then they can certainly act on behalf of the estate, but without going through that, they do not have the legal authority to act on behalf of the estate.
Okay, that's important. A lot of folks, for some reason, think that just because they're a surviving spouse, that they can do things.
We may get a phone call and someone may say, I am the executor in the will, but they are just simply nominated in that paper, so they must come before us to be formally appointed.
And we'll talk a little bit about some of the pitfalls about getting appointed. Joy, what does it mean to be qualified, or what qualification? What do those terms mean?
The term qualified or qualification is simply the formal process where one obtains legal authority to act on behalf of one's estate.
Okay.
Yes, sir. Okay.
Now, Bill, in Loudoun County, how do we begin the process to get properly qualified?
The first step should be to contact one of us in probate, and that can either be done by phone or email. We also have a website, and we encourage people to look at the website because it has a lot of information. Now, when you contact us, we're going to discuss basically the nuts and bolts of what's involved in the probate process and attempt to work your way to be able to do that. And we do schedule all formal qualifications by appointment only. And when we think you're ready to schedule an appointment, we will put you on the appointment calendar to move forward.
That's good. Now, Julie, how soon can an appointment be obtained in Loudoun County?
In Loudoun County, we try to get an appointment for the customer at least within a week's time. We do understand there are situations where we may have an applicant who's coming out of state or has already been in state for service. Then at that time, we will try to accommodate any requests that they may make at that time.
Okay. Well, week's not bad.
Right.
That's pretty good. Now, Lori, what should I bring to my appointment to get qualified?
The paperwork that we request to be brought to the appointment include an information form, a completed information form, completed list of heirs, and completed probate tax form. These forms are available on our website. We also do request, if possible, if someone has the means to email or fax these documents ahead of time, if we're able to receive them prior to the meeting, we can complete the remaining paperwork. Once the client arrives, we'll be ready to go and take care of them right away.
That's an excellent suggestion. Now, we did post on the website, on the screen for our viewers, that website, which is www.loudoun.gov/probate. So there are these documents that people do need to complete in advance, and it's encouraged that they do so. So one of the big keys, that we run into in the probate process, I know we've talked about this a bit before when we were preparing for the show, was understanding the need to be bonded. Okay, everybody has to be bonded, but can you explain why, Bill? And what does that mean to be bonded?
Bond is basically insurance that the assets of the estate are going to be properly administered by the personal representative. The personal representative is required to sign the bond. It's basically their pledge, our agreement, that they're going to pursue their duties correctly. And what they're doing by signing the bond, they're acknowledging that should they misappropriate any estate funds, that they will be personally liable to make up any loss of assets to the estate. In other words, the bond can be called. That's what they're doing when they sign a bond.
Okay.
And it can be bond with or without corporate surety.
So to get a bond with corporate surety, of course, is not a simple process, and so when people call in to begin the process, you will certainly inquire of them if they need to be bonded.
That is correct.
With surety.
Yes.
And if they do need to be bonded with surety, there are local bonding companies that actually will be able to provide that assistance. I know you've listed some people that are available to help with that.
That is correct.
So,
yes, they do.
But they do have to, if they have to get surety on their bond, that has to be completed before they can come in and see you.
That is correct, because if surety is required on the bonding company has to appear at the appointment to sign the bond form. And if the bonding company is not there, the clerk cannot do the formal qualification process.
So in the case of a will, the will could waive the surety on the bond. But if someone's coming in to qualify as an administrator, they're going to have to be bonded with surety.
In most cases, yes.
Okay. Okay. Let's talk about the qualification appointment. You know, we've gotten the necessary surety bond if we need one. The forms have been sent in advance, and so you folks have received that. So, Joy, where's the probate office located?
We are located at 18 East Market Street, and that's in downtown Leesburg.
Okay. And so when I arrive for my appointment, what should I do?
When you arrive to the courthouse, you will go through security. Once you go through the security checkpoint, you will go up one level and make a left, and that's going to bring you into the clerk's office area.
At the clerk of the circuit court?
Yes, clerk of circuit court.
Very good. Mm-hmm. So when I arrive there, do I have to do anything special to let you folks know that I've arrived? You
do. Once you make it into the clerk's office area, and again, that's clerk of circuit court, you will go either to your right, which is one of our counters. There are wayfinding signs, but we actually are located on the left-hand side of the clerk's office. We do actually have a courtesy phone on the wall, and our extensions, the 3 of our extensions, are posted at that location.
So I pick up the phone, dial the extension of whoever I'm supposed to meet with, and then we'll connect and get that process.
And then we'll come out and assist. Yes, sir.
Very good. So tell us, Bill, what happens, well, Lori, let's go. What kind of questions, Lori, can we expect to be asked during a probate appointment?
One of the main first questions that is critical is verifying that they're in the proper jurisdiction. So we ensure that they're a Loudoun resident. If there's a will, an approximate value of assets in the decedent's name solely, possibly if there's any real estate in Virginia, Loudoun, or outside of Loudoun. And we begin to gather information on the list of heirs as well.
Okay. So, Bill, we answer those questions. What else happens during the course of the normal probate appointment then?
We present this original will, the issues of the time we see it, and we do make sure all the forms are done, properly signed, take the oath of office, get the bond signed, explain their duties after they qualify, such as filing inventories and accounts, and have a package of informational handouts. We compute and collect the proper probate fees and taxes that are due. Then once all that is done, one has the authority to administer the estate.
Excellent. Now there is, I know that we've talked about that there is a probate tax that's due, but is that the same thing as an estate tax?
They are 2 different taxes by statute. Almost all estates pay probate tax. That's based on the value of the assets going into probate tax.
Okay.
Now, estate tax is basically an inheritance tax, and it's my layman's understanding, because I'm not a tax person, is that you have to have several $1 million in values before one has to worry about an estate tax in Virginia.
That is true. I can tell you that's true. Lori, what are some of the common issues that that you run into as a probate clerk during an appointment that cause a delay in getting somebody qualified?
A few of the common will a copy of a will is presented, and we must have the original to proceed. The family may not be able to locate the original will.
Okay.
Possibly they're not prepared to pay the probate fees and taxes. And sometimes we do realize at the time of the appointment that a secured bond may be necessary.
I see. They may have to get a surety bond.
Correct.
Okay. Now, Bill, given our transient society, a lot of folks that come in to qualify are not residents of Virginia. Okay, can they qualify to be the executor or the administrator?
Yes, it is possible. They may be required to always get a bond with corporate surety. And the second thing is they have to formally name someone who resides somewhere in Virginia to be their Virginia resident agent.
Okay. Okay. Well, we're coming to the conclusion of the probate process and getting qualified. Joy, what does the applicant receive to show that they're actually now in charge?
All right. They actually will receive what we call as a letter of qualification.
Okay.
That letter of qualification will include the clerk's original signature as well as our court seal.
Okay.
Yes.
Now, when they, Lori, once they're qualified, they have a certificate of qualification. I know they have to give some notice to the heirs at law and the beneficiaries under the will. Is there anything further they have to do with your office?
Yes, they are required to file an affidavit of notice with our office within 30 days from that date of qualification. And basically this document is certifying that the personal representative has notified all the appropriate parties.
Okay. Now I know that we previously had talked about this with the Commissioner for Accounts from Loudoun County, Mindy Hetzel, and asked her, she talked about how your office works closely together with her office, and one of the things we asked her about is, does she get involved in trying to make sure that this affidavit of service has been filed? And we asked her that question. Here's what she had to say.
So the affidavit of notice is the document you're referring to, and it's supposed to be filed 30 days with the clerk, not our office, with the clerk, within 30 days of the date of qualification. So after those 30 days, the clerk doesn't really have a mechanism by which it knows who's filed and who hasn't. So at 4 months, we receive the inventory, and at that time, we make sure that the affidavit of notice has been filed. So for each inventory, we cross-reference affidavits of notice. For those that have not been filed, we do our same procedure. We send out a late or a request letter, then a late letter, and we'll follow up on it until it's actually filed. So we make sure that the clerk's office gets that affidavit of notice and it's properly filed before we will approve that inventory.
Okay, so we're at this point, Lori, is there any other reason why somebody has to come back to the probate office once they've qualified?
The only time it is required for a person to meet with us in person is for that formal qualification and to take their oath of office. They can certainly revisit our office if they would like to collect additional letters of qualification or copies of documents, but typically we handle that through the mail.
Okay. Well, Bill, we've covered a lot of ground here. It seems really complicated. Okay. So my question to you is, does someone need to get a lawyer to help them get qualified to probate an estate in Loudoun County?
Under Virginia law, one is not required to have an attorney to assist them for the qualification process. But on the other hand, as you can see, at times it's very complicated. And at times, the clerk may make a friendly suggestion based on something they see in the process that one may be well advised to consult with an attorney for some aiding guidance. Because what you have to realize, as clerk, we can only answer procedural questions, which is what the forms are. We can help you with that, but we as clerk cannot give out legal advice, and so in those situations, one might be well advised to consult with an attorney for help.
I think that's good advice. Now I will say, point out to our viewers, and we posted on screen the first page of a booklet that's been prepared by Mindy Hetzel Commissioner of Accounts, as well as Bill Loy and Lori Gordon from the Probate Office in Loudoun County, that gives you some indication as far as duties of an executive or administrator and things you need to do. Very helpful booklet, and it's available on the website at Loudoun County Circuit Court Probate Division. Bill, Lori and Joy, thank you so much for taking the time to share your thoughts and suggestions and all this valuable information. And thank you very much for the wonderful job you're doing serving the citizens of Loudoun County.
Thank you.
Again, thank you for coming and visiting us today.
Thank you.
Appreciate it.
You're very welcome. Without a doubt, probate can be complicated and confusing. But Clerk of Court Gary Clemens and his team of Bill, Lori, and Joy at the Probate Division in the Loudoun County Circuit Court have done a wonderful job of making the qualification process simpler and user-friendly for those who need to probate an estate in Loudoun County. Beginning when you call to make an appointment and learn you may need to arrange for a surety bond and that you need to complete certain documents and submit those in advance to them, to when you walk through the front door of the Loudoun County Courthouse, head upstairs to the office of Gary Clemens, Clerk of Court, and pick up the phone in the waiting area of his office to call Bill, Lori, or Joy to let them know you have arrived for your scheduled appointment with them. To when you sit down to complete the necessary paperwork and get legally qualified to start probating an estate in Loudoun County. To when you leave the courthouse, ready to continue on your probate journey. Each step has been organized to make this a pleasant experience. And be sure to check out all the useful guides, forms, and checklists they have assembled on the Loudoun County Circuit Court website for your use before and after you started probate. This brings us to the conclusion of our show today. Getting qualified in Loudoun County Probate Office is just the beginning of your probate journey. So as you take a seat on the probate train and it pulls out of the station at Loudoun County Courthouse, toot the train horn and congratulate yourself on a job well done. The next stop for the Loudoun County Probate train will be a visit with Mindy Hetzel, the Loudoun County Commissioner of Accounts. On behalf of myself and the Probate Nation, thank you for visiting with us today.